Welcome to session 3. I'm here with Jose from Iprotect, the founder, and I'm from Trust Property, the founder. And I want to start off today with questions about married in community of property. So I've had this crazy little saying that I say to people, mainly to shock them and to get them to think about it. I say, when you get married in community of property, you're like a half a person. Because everything you sign for, you need the other half. Or if you go to the bank and you take a loan, you've not just loaned it for yourself, but your other half is in on that loan and at risk for that loan. Am I correct in saying that?
Yeah, so the Matrimonial Property Act, which deals with community of property estates, sets out the parameters or the criteria. So in the event that you encumber the joint estate, surety loan, liabilities, both parties must sign. There is an exemption under section 16, I think, where if you're in business, you can sign on your own, but you cannot encumber the joint estate. But otherwise, you're like two halves of a whole.
So I never knew that till you corrected me last week with a client. I'm standing with a client who has got
the property. Huh?
Yes, and she has got a company through you, and the company's shares are owned by the trust, and she buys property in the company. And she was telling me she doesn't need her husband's signature, even though she made a community property. And I was like, no, you're half a person. So that's interesting. So that is how one almost gets around that to an extent, because if someone went for you and you married in community of property, they probably will still try. Not at all. So completely exempt.
You've got structures, and think of your structures as distinct from you as I am. Okay? If I get into financial trouble, is it your problem? Or vice versa? No. So remember, trust is not owned by anybody, which is why it's such a great asset protection vehicle. Nobody owns a trust. Okay, and that's the entity we use to close the loop, because a company, whilst being a juristic person and separate from you, is always owned by somebody. Right. Another shareholder could be another company. So you could have this long daisy chain, but ultimately, to give you the protection, you bolt on a trust to be the shareholder. So shareholder is not owned by anybody,
okay,
which is where you get the protection. So even if you're in community of property, they can't come after you. However, between the two parties, that is where often the structure could get pulled into a dispute on divorce, because it can be potentially argued that the spouse has set up this side hustle through the structure to denude the joint estate, because now you've been accumulating wealth outside of our arrangement, which is in community. So that sometimes is challenged, but can be difficult to crack those entities.
Okay. But the bank cannot come and challenge it. So for example, if I went into business, let's say you and I are married and we go into business together, I go into business and I make a very bad mistake and I'm the only shareholder and director or jointly, whatever. You are at risk for that.
Yes, because the community estate shares all the liabilities.
Now, if I'm in a company and I'm the director and the shareholder, but I'm the director, but the shares are owned by the trust, then no.
Can't touch me.
Yeah. Wonderful. So is community of property a bad idea?
Totally.
To me it is. Yeah.
That's
okay. But if you have already gone and done that, one of the solutions might be...
There could be a solution, but still, unless you're really in it for love, you should be just considering an antenuptial anyway.
We are meant to be in it for love.
Yes, but the game's played on grass. Reality tells you something else.
60% divorce rate, yeah. So
exactly.
Later, the love is a bit missing.
Exactly, it's a movie concept too. Really good. So being facetious. So there's something called a post-nuptial marital regime change that you can execute. Okay. So you can go to court and say, look, we are very young and very in love. We just got married in Mauritius. Now we COP or whatever the case is. But you can apply to court and they will change your marital status.
Oh, fantastic. Then you can be by anti-nuptial contract. Yeah. Okay, wonderful.
With accrual order.
Okay, wonderful.
2 options as well.
So you can change it. Okay.
Everything changes.
Because right now they're sharing every debt. So I always say to people, the biggest problem is not actually whether you're in love and to protect yourself from your partner. The biggest thing for me is to protect yourself from the banks. And even SARS, am I right? Like if one of the parties is in trouble for tax,
you're all in.
Both parties are in trouble for tax.
It's one estate. Okay.
And Shem, I had a friend many years ago, 20 years ago. She was a housewife, and she was a very proud housewife of this beautiful house. And she had no idea what her husband was up to. And the next thing, she ended up divorced, and she couldn't even sign for a lease because his business went down, and she was in community of property. So yeah, I think it's a good idea.
Old problem, as you're aware, and this is why we're so big on asset protection, but also just to add a point there, I don't know if you're going to get to it, death. If you're in community of property, the whole estate is frozen, not just the dead half or the dead person's half.
Oh.
And you pay executors fees on the whole estate, even though your half shouldn't be, because you're still alive. But you see that.
Are you sure about that? But I know you're sure about it, right? that is terrible.
It's insane. So now you've got an executor who's administrating the entire estate, and you are going to have to pay this person 3.5% on your half.
No way.
Yes, absolutely.
Okay, that's insane.
Exactly. That's why we offer zero executors fees, but we'll get to that.
Yes. Well, tell us quickly about that. So if you set up a company and a trust with Iprotect, you have zero executive fees in your private capacity. Even if you went and bought 1 or 2 properties, which I might have done in the beginning in my private capacity, and it's still in my private name, I still will pay you zero executive fees. I mean,
so there are some estate charges like the master and certain advertising, etc.
Sure.
So it's a big passion of ours because people think they're immortal,
yes.
Even though we know we're not. But we've got this aversion to discussing death, so
yes.
we just kick the can down the road rather than deal with a holiday and all these good things. But we see the damage that is done, and it's like a murky area. And I sort of don't want to disrespect anybody in the industry, but it's not exactly like everybody's out there with this big clarion light with like bold lights and going, guys, this is how it works. So let me give you a quick example. Let's say you're worth 11 million.
Yeah.
You've got 10 million rands worth of liabilities.
Yeah.
Your net is 1 million.
Correct.
The executive's fees on the gross amount. So take it on the 3.5% of the 11.
Yeah.
So if I take my net,
350,000 rand.
suddenly 350 of a million is 35%.
They're getting more than one of my children.
Exactly, they become beneficiaries. Then the other challenge you have is that nobody also tells the person executing the will that they get 6% of the revenue that flows into the deceased estate.
Or rental income.
Rental, dividends, interest, and so on and so forth. Okay. My conspiracy theory why estates take so long to wind up. If I'm getting 6%, not as bad.
True.
Okay, so anyway, I've also seen that this is really an administrative exercise. Okay, so you can train somebody to just go through this process, but again, people don't think about the complexity. So we're quite happy to just sign up for 3.5% or the 6%, or both actually.
Yeah. And
it costs a lot. So just recently we threatened a trust administrator, which is a big national bank, not the national bank, but one of the major banks, and to wind up this estate, which was quite substantial, but all they had to do literally, Jenny, 12 share certificates.
No.
It started at 7 million rand in fees. By the time we were threatening to bring all manner of legal action and approaching the master, they eventually came to the party because they do bank with the clients or the surviving clients, etc. Got them down to 3 million. 12 pieces of paper.
Wow.
Okay, so I see this as a cost center, and you know that our method or our sort of model is always premised on fixed fees. Okay, so we saw this inequity, I believe. So now, on your death, they take a big chunk out of you. And firstly, we want to structure you so that you don't have a big estate. But even if you do have a big estate, this is not rocket science. It's administration. You've got to go through a couple of processes. So why should you be rewarded on a percentage basis? So we've introduced this zero executives fees, and our solution is a cost center, but it's not for everybody. And we'll get to that in a bit.
Absolutely. I like what you said earlier when we were talking, and you said, why pay too much tax voluntarily? Not the right amount, just too much.
Give a dog a bone, legally.
And we want to do everything legally, so it's about how do we pay as little tax as possible. And I think what people don't actually add up in the long run is how much they save by just the transfer duty alone on the property. So transferring the property, tell me now if I made in community of property, because we're sort of on that subject, right? And one of the spouses die. The half of the house, let's say they only own one house for this purpose, half of the house gets transferred to the other surviving spouse. Do you then pay transfer duty on the half?
No. Okay, so in terms of our law, the Transfer Duties Act, there's certain exemptions. When an individual inherits immovable property, no transfer duty.
Okay, so the only thing they're saving there is the executive fee, which would have been 3.5%
still
of
paying,
both.
no, paying the executive's fees, not paying transfer duty.
Sorry, I mean, if you were now not in that problem, in that situation, then you would save the executive fee only.
If you were in a structure.
Yes, if you were in a structure, thank you.
And the CGT and the estate duty, which we haven't got to.
CGT and the estate duty. Can we talk about that?
Yes.
Okay, so give me an
So
example.
ideal, optimal position, you own nothing. Right? So some countries have got one or the other, we happen to have both. Okay, so a lot of countries do not have death taxes, inheritance taxes, that type of thing. We start off with capital gains tax. So it was introduced in 2001. Any asset you have that's appreciated in value from 1 October, okay, till the date of your death, okay, will trigger a capital gains tax. Now, most people with property, you should be in a position where your estate will be in the top tax bracket. So 40% or 45% gives you 18%. So that's how you get to that 18% number, right?
Yes.
So I bought a property at $1 million. I die and it's worth 11. I've got a
Yes.
capital gain of 10.
Yes.
I'm going to be paying 1.8 million just because I've stopped breathing
Yes.
permanently.
Yes.
Okay? So if it's
And
in a
that's got to come
structure,
out of your estate.
exactly, and SARS starts jumping up and down after about a year. They want money. Okay, so if it's in a structure, the structures don't die. So what's 18% of zero?
You just add that up and then go, okay,
1.8
so now
million.
that's
That's just on the CGT, but then throw in the executives fees, 3.5% of the 11. It's another 400k. Thank you. Okay, there are exemptions before anybody starts saying there aren't exemptions, but they're like huge. On your demise, it's 300 grand. What a joke. Your whole estate, the capital gain exemption is 300,000.
Oh, wow.
Joke. If it's your primary
So
residence,
you're saying the first 300,000 is exempt?
first
Okay,
300
got it.
no tax. Anything over that, CGT. And you also get a 2 million rand exemption on your primary residence only of 2 million.
Yes.
Okay, so let's say that home, that example went from 1 to 11, the gain's 10,
Yes.
you would take off 2,300,000, you'd be taxed on the rest.
On the 8.
Roughly. Simple. So now if it's in a structured nil, I'm going to take nil every day of the week. Okay, then the executives fees, 3.5% plus VAT. Most administrators are VAT vendors. So that works out at about 4.025%. Massive chunk again.
Now let's just say you were married in community of property and your partner that just passed away, sometimes from the stress, had actually bonded, I'm sorry, but it really happens, has actually bonded the maximum on those properties. You actually don't have the 3 million to pay.
Look, there's ways, there's workarounds. So generally, and most people would do this, especially community of property. So I already own half, okay, that's not being disposed of, but it's the deceased's half. But they generally will leave it to the spouse. So
Yes.
when you leave any asset to a spouse, it's exempt from CGT. But I like where you're sort of heading because people don't think about this, and some people who are married ANC could really have a big problem in this regard. Married ANC, 2 halves, okay, or they own the property jointly rather. The deceased person, now maybe this property is highly bonded and there are other taxes, okay, and there are bonds, and maybe there's not enough liquidity. You end up losing your home because you haven't made provision for that. Or you as a surviving spouse don't have the means to settle the bond, so you've got to sell the home.
Yes.
Okay, then it's going to trigger CGT anyway because you've got to get rid of the place. Crazy.
And you know, I've had one person in the last year that actually, her partner died 6 years ago. She's still just paying the bond because the banks haven't clicked. I don't know where the information's missing, but she just pays her bond.
Well, she's a very lucky lady, but I'll tell you what's probably happened there. There's an obligation on the family of the deceased, the executor, whoever's got the will, to lodge it with the master. And I think what may have happened is that the nominated executor is sleeping at the wheel, maybe deliberately. It could be her, and she doesn't know what to do, and she just kicked this under the...
And when are you meant to do that by?
It's like 40 days, if I'm not mistaken.
Oh, really?
No, it's chop after death. And I can get you all the intel on the time frames because, like I said to you at the beginning of this chat, the administrative process has got like specific timelines. Okay, you've got to then advertise the death. You'll see that in the newspapers. Nobody reads it. Do you read it?
No.
I'm an attorney, I don't read it. So it'll say, hear ye, we're calling all of the creditors of the late ABC. because you've also got a time period to lodge your claim as a creditor.
Okay.
Then the executor will check it out and say, rubbish, kick it out. Then the
Okay.
creditor will either challenge that or accept that. But generally, it's easy to prove your debt. You know, there's a credit card debt or a bond or a car payment or a car debt, etc.
One of those questions was, can heirs be left liable for debt?
No, fortunately,
Not.
the old pound of flesh from the Roman times is
Not
gone.
anymore. Okay, good.
And literally, you do not inherit the sins of your parents.
Okay, got it.
Or if you're a beneficiary. So it does stop, and this is why you have this procedure. So you may find that if the deceased was insolvent at the time of his death, his estate will then be wound up as an insolvent deceased estate.
Right.
So most people have got goodies
Yeah.
to disperse, and everybody's waiting for somebody to kill over to get something. But if there's nothing in the bag,
Yeah.
then it goes via the Insolvency Act. So
Yeah.
you've got a deceased estate, so there's that administration coupled with the Insolvency Act, which transpires before it can be wound up.
Okay.
And so, right, nothing to see here, nothing left. Then in a normal insolvency, you may have heard people like really bleed because they are owed money. This person cannot pay, so there's a sequestration of an individual or liquidation of a company. And you may find that the creditors have to pay in to wind up the whole insolvent show.
Oh, wow.
So now this person's dead and they owe me money and I may have to pay in. No, thank you. So a lot of people just do not submit the claim, but that's what.
And that just excites me again that there's nothing like that happening on my demise.
Yeah, well, you don't have that problem
because everything's sitting in
you're
the
planning,
trust.
guaranteed 100% you're going to die. So why not plan to avoid all of these issues for the next generation?
Exactly.
Besides all the other tax benefits and other things we can discuss.
Yes. Okay, so I wanted to talk, because we spoke a lot last time about the roles of the trustees. But now we're in a company, and the company buys the property, and the property is owned by a trust.
No.
Sometimes.
The trust. Oh, okay. Can also be a trust can
mostly-
directly own a property. Or
Yeah, but this is
trust
the
owns
company
shares.
owning it.
No,
The company
trust
owns the
owns
property.
shares, the company owns the property.
Yeah, that's what I said. Just
Just to clarify. You understand?
Perfect. Okay. What are the roles of the people involved in the company? So there's mostly just a director.
A director, minimum one.
Yeah.
Can be many directors, but you've just complicated your life. So you can have more than one director. So it could be the partners that
Okay.
maybe acquired a property jointly through one company, or it could be husband, wife, or family, or whatever the case is, but minimum one director.
Okay.
So a director operates in a fiduciary capacity to, there's sometimes personal liability to the directors as set out in the Companies Act.
Yes.
So just be careful you don't transgress that. But the director is basically the person who makes the decisions, on behalf of the company, but subject to the oversight of the shareholder, which is a trust. So you could have trustees that are not directors.
Yes.
They will then set up parameters for the director and set up the scope of the authority.
Now let's say that the two parties that were initially the trustees, and there's one director out of the two because of the liability that could come with it, and now you pass away, one of the two, and the other beneficiaries step up to the plate and become a trustee.
If the deed sets it out,
If it's
or the
set-
letter of wishes.
If the letter of wishes set it out. Now, does that secondary trustee, the one that became a trustee later, have the same rights as the other one, even though the other one's a director?
No, so split the roles and the entities.
Okay.
Firstly, the entities.
Okay.
The trustees have certain powers as set out in the trust deed, and that's one kettle of fish.
Yes.
So they will decide around what happens with the trust assets.
Right.
Okay.
Which is
Well,
houses owned in the company.
Well, let's just to
Let's just say.
correctly say the shares of that company are sitting in the trust.
Got it.
So the trustees will say, we own shares, or we hold these shares on behalf of the beneficiaries in the trust in that company that owns 10 properties, and we're going to mandate the director to do ABCDE. But you see, the director roles, obligations are different to what happens in the trust. Okay, so
But
trust is the owner of the
trustees
shares.
sounds like it is in charge a bit there.
Well, not necessarily.
Of the
To really
director.
clarify, let's use like a really stark example here. Let's say Anglo-American, big company. Everybody knows about that. There's shareholders and there's directors. Imagine if each shareholder of Anglo was running around giving barking orders at directors. Get no business done. So shareholding is one thing.
Okay.
Directorship entails the control of the company, the operations, the management. Okay,
Okay.
directors can then have committees and managers and supervisors and employees. Okay, so if you look at the structure of a company in that sense, it will clarify what the roles are. Okay, so trustees are controlling the owner. The owner dictates to the board of directors what will happen within the company.
Okay. I still have a question about that. Like, let's say, okay, let's go quickly via this route. I wanted to ask if we've always said that a trust must not be a trading entity. Okay?
In our book, yes.
Yeah. The company, however, that owns 10 properties trades in properties,
Yep.
and there's income on the properties, and you pay the bonds of the properties.
Yep.
So that is it, or can one put other expenses through that company too to run it?
Okay, so it's a pure property company. Okay, so anything related to the property obviously is deducted.
Okay.
However, the Tax Act sets out certain criteria of when, excuse me, an expense will be deductible. So if you are running around and looking after the properties, your petrol, cell phone,
Okay.
anything related to the conduct of the business of this property
Okay.
in this company is deducted.
Okay, so let's say I buy 100 properties. I'm just creating this in reality, right? For the future.
That's it.
Yeah, it's done. So I buy 100 properties. Now, on my demise, there's a director of the company, but my children are trustees of the trust.
Yeah.
This director can't suddenly decide that they wanted 200,000 rand a month salary for running the 100 properties. No.
So let's do
Not
you
without
really,
their agreement.
Yeah. Okay, so if you're going to get to that point at 100 properties, you're running a pretty slick professional property business. Okay, you're getting there, almost there. Another 5-6 times and you get 100.
Yeah.
You probably would have, and I know you're in the business, which is different, but for people who aren't, you'd probably have like a professional manager
Yeah.
who could be a director too, managing these properties. You would have an employment contract that would set out their remuneration, their roles, their responsibilities, their obligations, their reporting, termination, etc.
Okay.
So remember, the company doesn't die. You would have an arrangement with the director or with the employee around these properties. So the fact that the big cheese is dead, that doesn't mean the minions are going to run amok now. Okay.
Got you.
So there is structure.
Okay,
And this
thank
is why
you.
it's even better to often have these.
Thank you. I want to speak again about what happens when we pass away. So, for example, if you have left your money to a minor, let's say you've only got one heir and they are 14 years of age, that money goes into a guardian fund.
Not necessarily. Okay, so
If you never had a will, sorry, did I not say that?
No, you didn't.
Ah, thank you. If you never had a will, then that money goes into a guardian fund.
Again, not necessarily. Let's backtrack a bit.
Okay.
Because I think there's two things you're trying to cover there. If you don't have a will, your estate will be sort of administered via the Intestate Succession Act. So you've got the Wills Act that deals with valid wills, or what the validity or the issues that must be in a will for it to be valid. That goes under normal succession. If you don't have a will, then there's a whole lot of rules on how an intestate deceased estate is wound up. Then there's a whole formula, and it goes surviving spouse and children shares, and it goes down to various generations, and if there isn't, then it goes up to parents and then laterally. So there's a whole formula around that.
Okay.
But the question you asked initially is a 14-year-old person. So I could have a will, or I could not have a will. So intestate or testate, but a minor in our law cannot directly inherit.
Correct. Yes.
Okay, so whether it's intestate or testate, those proceeds or funds or assets will then be held by the Guardians Fund. Have you read
It's
anything?
our government, isn't it?
No, it's worse. I mean, our government is bad, but this is a division of the government called the Department of Justice.
Oh, wonderful.
They run the Master's Office.
Oh, wonderful, because that
The
was my
Masters-
next 5
Have
questions.
you seen all the media? So now,
Not really, but I've
Okay.
got questions about it.
we fortunately have been getting a lot of press on the Master's Office, because as practitioners, people think we're just dragging our feet and that are bad. You can't get in there, you can't get anything out there.
Yes,
It's just
literally.
insane. Okay, so
That's
people are
my
waiting
experience.
6 months for a letter of wishes, a letter of execution. You need things to be happening, sometimes longer than 6 months. It's really, really frustrating. So now imagine that wonderful organisation, so this is all due respect, are now running the funds for this minor. In a lot of instances, they don't even allocate the funds correctly to the person. So they've got like this massive Guardians Fund with unallocated proceeds, funds.
Crazy.
And then the minor must go, imagine master's office, get your tithe or your little bit. So do not penalise your poor unless you want to.
Yeah.
But yeah, minors.
Now the master's office, what all does it control in terms of trusts and in terms of companies?
No, so companies controlled by CIPC,
Mm-hmm.
Commissioner for Intellectual Property and Companies.
Mm-hmm.
That's companies CC.
So it's not connected to the master's office.
No.
The trusts have to be registered there.
At the master.
Mm.
So master is one office. Remember CIPC used to be bad, terrible. Fortunately, they've digitized it, so it is quite automated and it works most of the time, so which is great. But 5, 6, 7, 8 years ago, it was a disaster. Same thing, waiting months and months for change of directorship or formation of a company or termination.
Do you think the masters might get there?
They are digitizing it, but we're a long way away. Okay, so the master looks after deceased estates, trusts, and insolvencies. It's the other division that the master handles. Liquidations and sequestrations.
Okay. And at the moment, I know that there are people that are getting nothing out of it. And even changing trustees on a trust, in reality.
Same thing.
Yeah.
Goes in, nothing comes out.
And are you allowed to apply it different?
No, so the
Got to be in
master,
your
yeah, so it
province
works like
or
this.
something?
No, there's sometimes multiple masters' offices, like Gauteng's got Joburg and Pretoria.
Okay.
A lot of provinces only have one. Durban's got Durban and Maritzburg.
Okay.
Cape Town's only has one.
Okay.
Grahamstown, Eastern Cape, Bloem, one. So you've got to register the trust or the deceased
The very
estate.
first trust.
In
So
any
in
trust,
other words, as soon as I buy a trust, well, I don't buy a trust, I form a
Establish
trust.
one,
And then I buy a company. In order to put a property into the company, and the shares are owned by the trust, I have to have that trust registered at the masters. The same masters that's got all the corruption and problems that it's got. Okay.
Okay, so you've
So how
got
do
a
I do
multiple
that and
thing.
I buy the property in
Okay.
time?
So the master will register the trust, okay, because that falls under their ambit. You will incorporate a company with CIPC. Okay, so remember, there's also two things you must always consider. One, ownership of the equity. The other is the company that must be formed in order that you can acquire the property. So there's a couple of moving parts here. If it's Desperado'ville and I have to get this off in quickly, you can maybe just get a shelf code. Now I've got a company with a registration number, I can make an offer.
Yes.
Right. That's that part done.
Yes.
Now I've got to deal with the ownership of the shares, and that's what could be an obstacle or could take long because of the delays of the master. Now what you must remember is that in the event that you move the shares of a company that holds residential property, or let me qualify that, if more than 50% of the assets of a company is residential property, then the moving of the shares triggers transfer duty. So you don't want to have the company pay the transfer duty on the acquisition. Then you move the shares into the trust post-registration and you pick up duty again. So that's why you're going to have your structure in play.
If it happens 2 weeks later, it's not a problem.
No, you read the act. It's the transfer of shares. Okay, and there's a couple of other riding criteria. So this is why, don't even get yourself into that pickle. Make sure your company is in play, you have your trust owning the equity, and then you don't have to worry about that problem.
Okay. Now let's say my property is already in my private name. Now I decide I like what you're saying and I want to transfer my property into a company, and that company's shares are owned by the trust. Do I pay transfer duty?
If you don't come and talk to us.
That's what I thought.
Okay, so any transfer of immovable property will trigger transfer duty unless it's a VAT transfer, then it can be zero
Or if
rated.
it's under 1220.
Okay. Or if you buy from a developer, they charge you VAT, you don't charge transfer duty, but you're paying more because VAT is 15%.
Absolutely.
Okay, so we've got that out of the way. Then if it's already yours, you want to keep it, you can do a reservation of a usufruct, sale of a bare dominium to the company, and you could find that there's no CGT and there's no transfer duty depending on the value of the bare dominium. That's one option. Or there's something called the corporate rules, where you can sell the property to a company in exchange for shares, no transfer duty.
So if I already did the transfer from a private capacity into a company and the shares are owned by the trust, and I now want to register a usufructuary right, Would there be any reason for me to do that?
No, it's already in the right structure. You wouldn't use that.
You wouldn't
so we
need it
use
then.
those
You only
mechanisms
use it in order to say
as a
transfer
way.
it to you.
Correct. Yeah.
Got you. Okay.
All right. Then, a lot of people can do these transfers, but again, as you know, we're constantly innovating. So the way we help our clients move these properties, because the share that you get in exchange for the property must be equal to the market value at the date of transfer, failing which you've got trouble. If you go too high, above the market value, you will have CGT. If you go too low or under the market value, the company can have a dividend. Okay, so there's a whole lot of anti-avoidance provisions that people must be aware of.
Yes.
And then we deal with, or we issue something called a capped share. Okay, because think about it, our whole thing is about succession planning. So imagine I have a property worth 5 million, I'll sell it to this company, I'll get 5 million rands worth of shares, normal shares. Property becomes worth 20 million. The shares as a whole are equal to the value of the asset in the company, isn't it? So the trust owns the shares in the company, but I also have shares in my personal capacity because I've sold the property.
Okay, I'm lost. Sorry, go again.
Okay, so this company starts out live like this. It's brand new, it's got no assets. The trust owns the shares of the company which has got no assets. What's the value of this whole structure? Nil.
Yeah.
Okay. So now I put a property, or sell this property into the company for 5 million. So the company has now got an asset worth 5 million.
Yeah.
But the company must issue me with 5 million rands worth of shares.
Yeah.
So now there's one shareholder, which is the trust.
Yes.
The other shareholder is me for selling the property in.
Oh.
Okay, so remember debits and
From,
credits.
yeah, so from you to
zero sum
them,
game, right?
Personal
So now
to
there's
them,
two shareholders. The property becomes worth 10 million. The
Yeah.
proportion of equity that I will hold relative to the trust is always going to mean that the shares that I hold is going to be equal to the value of the property. Unless you employ our solution. Our solution puts a cap on the equity.
Okay.
So trust owns shares in the company
Yes.
and it's zero,
Yes.
1 rand.
Yeah.
I sell property in for 5, but I get a special class of share, which puts a ceiling on that equity. Then it becomes worth 20. The 15 grows to the trust, and I'm stuck at 5 for it.
That's what I thought I was doing. That's why you had me lost. Okay, because I am doing that.
But that's why you are client.
Because the
That's why you do
whole
it properly.
intention is to grow wealth in the
structure.
trust, yeah,
Exactly.
or structure, yeah. Not to grow wealth over here where someone can
You've got to go to
just take
zero.
it.
You want to be zero.
I am a penniless pauper after I sell 2 little properties. I'll go do that right now. Okay, when you're buying a property in a structure, people are scared whether or not they're going to be getting a bond. So at the moment, only one bank is actually giving all the bonds, in my experience, and it's ABSA at the moment. Whenever anyone's applying for a property in a company, one other bank came to the party this month, but they're struggling to get their bonds. There's only like 1 or 2 banks that are bright enough to understand this whole structure.
It's not the banks, Jenny. It's the people that make up
Make
the
the
banks.
application, yeah.
So,
Yes, and
It's
that's
so
why I
ridiculous.
trained my bond originator
Yes.
to do it correctly.
because all their discretion's been taken away. So it depends on how high up the ladder you can get, because we deal with a lot of banks, and it's the person you deal with who understands the structure. You tell them what they need to hear, they tick the relevant boxes, you're good to go.
Absolutely.
You just walk in, you start at the bottom of the base of the pyramid, and you're just going to butt your head because they go, I need 3 years of financial statements. So you go,
Correct.
but I've just set the company up last week, it's new.
Correct.
Yeah, but we need 3 years of bank statements. You go, but
Correct.
it didn't even exist 2 weeks ago, do you understand? So there's like square peg round holes, and I've got to tick certain boxes, and this is where the disconnect comes from. But nobody should have a challenge in funding a property through a structure if you're talking to the right person, because it's still all about, is there value in the property? Yes. What is the loan to value? Tick. And the affordability.
And then you standing surety behind it.
Correct, that was one thing.
Yeah, so it's whether or not your name can handle it in its personal capacity, it should be able to handle it in the company.
Spot on.
Still struggling with training people about that, but yeah, 2 banks so far, we've got it right.
So we are working furiously to try and create our own facility, own solution.
That'll be brilliant.
So anybody out there who's got 10 billion, phone me.
Yeah,
Very
yeah.
first.
Phone me! Jose! Okay, so if you want to buy a forever house right now, How long would it take for us to set up the structure correctly?
Okay, we are at the mercy of the master. But we actually had a client in here, and it's amazing because they had digitized it, and we submitted 2 weeks ago Friday. We got this trust on the Tuesday. That was 3 days.
Okay.
I think the gods are smiling. Something
Yeah.
went wrong
Okay.
with the master. 'Cause
Yeah.
they got it right. But
Okay.
generally, if things are working fine, a couple of weeks for trust. CIPC is really fast these days.
Okay.
A couple of
Yeah,
days for
that's
a company.
easy.
Yeah. So if you're
So
making
you
a
can
big
do it
ticket,
within a month. If you're going to buy your
Oh.
forever house and you really want to do it in the right structure, you can do it within a month.
just again preparation. Yeah.
So what are some of the biggest mistakes buyers make with trusts when they're going to buy a property in a trust?
Directly in a trust.
Mm.
They will sign an offer without being authorized.
Mm.
Okay, so you have to be authorized.
Resolution.
Okay, so it's about the technicalities that either the buyer or seller will use to get out of a deal.
Mm.
Okay, so earlier we said we don't trade in trusts. That's sort of like not a hard and fast rule, because if you've got 10 children that are very young, it could be advantageous because you know the conduit principles, so the revenue can go into the trust, but then you distribute it to the kids, we use their tax rates. So we don't really sort of just say no to that. It'll be specific and particular, but you know, our government's been looking to close these things down for a long time. So they could either disappear. Now you've got a property in a trust and you didn't really want it there. So mistakes are just not being properly authorized, or the trust is not been formed yet, because you can only use, or you only authorize once you've got your letter of authority.
And the independent trustee.
Okay, so that's as a result of the Jackie Parker case. So, I mean, there's like a wide scale, sort of like they call it abuse of trust. And this is where you'll see creditors and financiers, bankers, they're very nervous around trust because they're slippery things. So, one very specific old case, just to digress slightly, it said in the deed that the trust cannot take on any liabilities, cannot get funding, cannot sign surety.
Wow.
Bankers sleeping at the wheel gave the trust the facility, and when there was a default, that's a defense.
Yeah.
No, you shouldn't have given me this bond.
Yeah.
It says you can't give me the bond, it's your fault.
Yeah.
Then there was another cause of action through unjust enrichment, but just to show you how tricky it can get.
And that's also why I tell people always to do it right, because a trust is not something you can just download from the internet.
Well, you can, but then what have you got?
Your trust deed is everything.
That's your constitution.
That's it, yeah.
Exactly. So it must be robust. You know, independent trustee, Jackie Parker case, the trust wasn't corporate, they had a big fight with the land bank, and then out of that ruling, Constitutional Court, they said, going forward, if a trust does have like any business trading, you must have a independent trustee, or that was the recommendation, and then the master issued a directive.
Okay, so now you have to have, and that's a good thing if they have it as a separate corporate entity being the independent trustee.
Well, it's more independent, it's more transparent, it's not just mom and pop sort of doing their crazy stuff. And it helps because this person could help you stop you jumping off a cliff, making a bad decision, so it's a bad tax decision. So independent trustee often helps in that sense.
So say I'm in, this last question for today. Say I'm in business, which we all know is very risky, and my business goes bankrupt. Can they touch my properties that are inside companies if I'm a director of that company?
No. So remember, the link is not you.
Yeah.
The only time they'd be able to go into the company is if the property company gave collateral for the trading,
Which it would never.
It should never, but remember, people do this because they're desperate and then they're never going to fail. So I can only succeed. So I've got a company with 20 properties in worth 100 million, and I need 20 million facility for my business. So I use that company as surety, and that's where all the dominoes start falling down and everything collapses.
You know when I met
if it isn't, separate.
You know when I met you about 28 years ago?
I never
forget. I never forget one of the first sentences you said, and I'm wondering what the percentage is today, but one of the things you said is something like 94% of companies failed in the first 5 years.
Yes, the number moves up and down.
Sure.
But
is
roughly,
it still so big?
I like the 80-20 principle. Yeah.
80% of them fail.
People go out of the cash in their pension. No, nothing about running a wimpy that's even more structured, a franchise. But my passion has been to design ball bearings or something. I don't know. They've got no business acumen, cash flow. So small business stats, that hasn't changed.
But that's why I like property, because it's like, it's real.
It's
Well, this
robust.